the last person that ever tried me like this died 30 days later. I pray for you.
Yep, that was a former judge who got arrested outside of a nightclub, and now she has just filed a reported $50 million lawsuit against the city of Atlanta and a police officer claiming she was falsely arrested, imprisoned, and her rights were violated. Oh, and I say she filed it because she's representing herself. Let's talk about the latest of Christina J. Peterson. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. So yes, we are going to be breaking down this new lawsuit filed by Christina Peterson, a former probate judge in Douglas County, Georgia, where she claims that her rights were violated when she was apprehended by police in the early morning hours of June 21st, 2024, outside of a nightclub in Atlanta. Now, before I even get into her legal claims, and I'll give you some of my take on the strength of it, got to go to the body cam here. Key piece of evidence, and by the way, comes up in her complaint quite a lot. So the body cam, as in many stories, tells a lot of the story. And we're going to start now with the body cam of the officer, where there is some sort of altercation happening outside of the Red Martini nightclub. Now, according to Peterson from her lawsuit, and again, we're going to get a lot more into this, it says, quote, this is her narrative. On or about June 21st, 2024, at approximately 3 a.m., plaintiff was present outside the Red Martini nightclub in Atlanta, Georgia, where she observed a man violently assaulting a woman by throwing her backward and repeatedly punching her in the face, while plaintiff remained separate from the assailant and did not engage in the altercation. Okay, so let's go to the body cam.
No, he just punched me. Everything for no reason. Right, no, let it go. Let it go. Let it go. Let it go.
That's a cop!
And that's on me.
She's a judge. Go get my the judge.
Go get my purse.
The judge just punched the cop.
No, I did not.
No, you did.
Go get my purse.
Christina, I have your stuff.
Thank you, baby. Thank you so much.
Okay, so as you can see, there's an altercation, and then there's this allegation that she hit a police officer, and she was ultimately charged with simple battery and felony obstruction for allegedly punching a police officer. I'll talk to you about what happened there with respect to the charges. I think that's going to be important. But Peterson, in her lawsuit, states the following. This is her version of the situation. Quote, plaintiff attempted to assist the victim and did not use or threaten violence against anyone. Plaintiff momentarily grasped the back of the assailant's shirt solely to interrupt the ongoing violence. Immediately after disengaging, plaintiff observed a different male individual unlawfully seize and hold the victim. Plaintiff verbally directed the individual to release the victim and briefly attempted to free the victim's arm from his grasp using minimal non-violent contact. Plaintiff did not strike, threaten, or use force against the individual. It was at this point, without warning, inquiry, or command, that defendant Wadsworth, so we're talking that's Atlanta police officer Keith Wadsworth, she's suing him too, by the way, seized plaintiff. At the time of the seizure, and that's a key word, seizure, right? Search and seizure, Fourth Amendment, we'll talk about that. At the time of the seizure, defendant Wadsworth had no personal knowledge of the altercation, had not observed criminal conduct by plaintiff, and conducted no investigation before using force. It's important for the analysis. We'll talk that later on. Defendant Wadsworth did not interview the victim, speak with witnesses, or otherwise attempt to determine plaintiff's role before acting. Again, this goes to the idea of what we'll talk about, probable cause, reasonable suspicion a crime was being committed. Plaintiff did not resist, threaten, or obstruct defendant Wadsworth. Without provocation or justification, defendant Wadsworth violently slammed plaintiff headfirst to the ground and applied compressive force to her neck and back while she was prone, non-resisting, and compliant before placing her in handcuffs. Plaintiff did not strike, attempt to strike, or batter defendant Wadsworth at any time. Plaintiff's identification was in her purse, which was on her shoulder immediately before she was seized. When plaintiff was knocked to the ground by defendant Wadsworth, her purse fell nearby and was retrieved by friends. After plaintiff had already been seized and handcuffed, defendant Wadsworth asked plaintiff for her name. Defendant Wadsworth nevertheless refused to permit plaintiff to retrieve her identification, ignored the information provided by witnesses, and continued to detain plaintiff. Now, I will say she is asked repeatedly on this body cam multiple times by officers throughout this whole episode what her name is, and she seemingly refuses to provide that information. All right, before we get into this, look, New Year's means a fresh start. But if you have debt, the threat to your financial health is going to stay the same. Debt is a silent killer. Interest compounds, fees stack up, and your financial problems are going to multiply. Doesn't need to stay that way, though. Our sponsor, PDS Debt, has helped hundreds of thousands escape debt, reduce what they owe, and take back control. So whether it's credit cards, personal loans, medical bills, PDS Debt has customized options to help you pay off debt faster. There's no minimum credit score that's required. They look beyond the numbers at your unique financial situation and design personalized plans to help you pay off debt faster and put money back where it belongs, in your pocket. Plus, they're A+ rated by the Better Business Bureau. Every month you wait is going to cost you more, but your way out starts right now. Don't wait for debt to strike again. Break free in 30 seconds. Get your free personalized assessment and the best option for you at pdsdebt.com/sidebar. That's pdsdebt.com/sidebar, pdsdebt.com/sidebar. I want to move on to what happens next in this body cam. So this is when she's in the back of Officer Wadsworth's police car, and she repeatedly defends herself, goes back and forth with the officer, and she also makes these religious comments.
What did she do?
Nothing.
Security was separating a fight.
Nothing.
I was
He
assisting.
hit a woman. He abused a woman.
She ran up,
And I
combo of like a push
and
punch,
he locked.
and
He put me in
then I
handcuffs.
placed her in
Because I was
handcuffs.
not in agreement
So
with
I'm gonna
his
take her for
disrespect
easy.
for a woman.
Maybe if you wasn't
I pray for
drinking,
you right now.
maybe if you wasn't, maybe if you wasn't drinking, maybe if you wasn't drinking, you would have known that I walked over there to separate it. So there you go. And that's why you're going to jail.
This woman has done nothing to him, Lord. He put his hands upon her, and I could not sit and watch and see it, Lord. I observed him, and he, in the name of Jesus, Lord, he has been touched by a devil and the demonic spirit, Lord, that he has put his hands upon me. You beat on that woman.
You know I had this camera on the whole time. So why you, what women did I beat? Which woman did I beat?
At the place we were just at.
At Red Martini, I was sitting in the car. You
It's
can't.
called Red Martini. It's called Red Martini.
That's what I said. I said
And
Red
outside
Martini.
of the place, you had put your hands on that woman without causing provocation.
What woman did I put my hands
She did
on?
not put her hands on you. She was not aggressive with you. She was not abusive with you, sir.
Yeah, I
And
think
you
you-
put your hands on her without
I
causing
think you had too much to. I think you had too much.
Juneteenth?
I think you had too much to drink.
Are you serious? I didn't have.
I think you had too much to drink because you can't remember what happened.
Hold on. You punched me to the ground.
All right, we're gonna sit here.
Yeah. Well, we're gonna be here all night.
That's fine.
Who is your cat? What's up?
That's fine.
Don't lie.
I don't have to lie. The camera tell everything. There's no reason to lie.
I pray to God you had your camera.
Yeah, it was on, so I
Was
can't
it?
wait. Yeah. Oh, well, God's answering your call.
Take me where I need to go because you're harassing me. It's called false imprisonment. Take me where I need to go. I should never be sitting in a police car for 80 minutes. And I am not under arrest.
You are under
You have not
arrest.
said I'm under. You are under
You are
arrest.
under
You have the
arrest.
right to remain silent. Any way you say anything you say it can be or will be used against you in a court of law. You have not told me that. You have not told me what I'm under arrest for. You have not told me what I have done. Let's be very clear. This is false imprisonment. This is malicious prosecution. Please understand.
Okay, so you're already getting a preview of what she would later claim in her lawsuit, right? Some specific language there. Now, here's what happens when the officer approaches her in the back seat.
Take me where you need to take me. I'm not scared of you. I'm not scared of jail. I'm not scared of none of it. Take me where you need to take me.
You need to take ready.
Take me where you need to take me. Stop harassing me.
All right, man.
I just pray for you.
So listen.
Take me where you need to take me. I'm
Ma'am.
not scared of you or jail. Please
Ma'am.
take me where you need to take
Listen.
me. No, I could give a take me where you want to take me. You're not
Ma'am.
going to harass me. And I'm not.
Ma'am.
No, I could give a
Listen.
No,
Listen.
you
Stop playing with me. You have beat a woman and you beat me to the ground.
Ma'am.
Take me where you want to take me.
I can't take
No,
you. I don't
take
have any
me.
identification on
And
you.
I don't care. You don't need identification. You have locked people up and you have picked up dead bodies when you don't know who bodies it was, but you picked them up.
Man.
Take me where you need to take me.
I'm trying to.
The last person that ever tried me like this died 30 days later. I pray for you. And I pray for you.
Okay, now that is something she repeatedly asks officers that night to call Cyrus Colley, who she says is from Atlanta PD. I actually looked him up. Does appear to have worked for Atlanta Police Department, even worked as a police supervisor. Seems at one point in time he ran for Douglas County Sheriff. But then this is the part where she arrives at booking and processing, and I will tell you, it gets very tense.
They cuff you to the car.
For what? I wasn't cuffed. I wasn't when it needed to. Shut the up. You look like a was trying to eat on me before and I never let him. Relax.
Never.
Shut the and stop touching me.
See? Don't.
Yeah, stop touching me. Get the fuck off of me. Stop touching. I got it. I can walk on my own. Don't touch me. Don't touch me. Don't touch me. I got it. I can walk on my own. Don't touch me. Listen to me. Where's your camera? You can't let me get in this car with this lunatic.
Give me your name. If you give me your name, then you'll be booked here. You'll be with us. Give me your name.
No.
What's your name?
No. Call. Do what
I don't know.
Call.
I don't know them people.
Call. You do
I don't
know.
know Polly.
Yes, you do.
Who is that? Where she work?
Him.
Where he working?
Atlanta Police Department.
Well, I don't know who that is.
Yes, you do. Do you know Fanny?
No.
Shadera Fanny. Yes, you do.
I don't know the people.
Yes, you do.
If you give me your name, then you stay here.
LeBob. Call him.
I don't know their numbers.
You don't know LeBob.
I know who he is, but I don't have his number.
Call him all.
And tell him I can't. How am I going to tell him? I got
If
somebody.
call him and I will say hello. And they will know who I am.
You can't do that. You gotta
Because
give
it's
me your name.
harassment.
You gotta give
It's
me your
harassment. And I will. Are you recording this?
No, I
You're
appreciate it.
losing me. Are you recording?
Ma'am, you can be here and stay here, and your friends can pick you up.
No.
The ones that were in the Audi.
Listen to
That's
me.
it. All I have to do is put your name and date of
No.
birth on here, so you can get booked in.
You
That's
a
all.
lie. You're a liar.
I'm telling you what I'm
Because
telling you
you're
with
accusing me of, and you're a liar.
disorderly
You beat
conduct.
that bitch to the ground, and you hit me to
You
the
have
ground.
the wrong person.
Yes, that was you.
No, you're drunk, and I'm
I
telling
don't even drink like that, you
come
weirdo.
on. And that's why you're acting like this.
Now, as I mentioned, in the end, she was reportedly charged with simple battery and felony obstruction. However, those charges reportedly were dropped. WSB-TV reporting that a judge dismissed them for, quote, want of prosecution. Now, that can be for procedural reasons. That can be there was an issue with the prosecution meeting their burden in a case like this. Although there is reporting that she still may be facing a misdemeanor charge of obstruction. This is according to 11 Live. But whatever the circumstances are, that could potentially be helpful to her case, particularly if you're dealing with a situation, if there was a problem with that specific charge or the elements of that charge. Not entirely sure, don't have more information about this, but potentially could be useful for her claims in the civil case. Now, I should tell you, she has been removed from office by the Georgia Supreme Court. This happened back in 2024. But it wasn't because of this incident per se, rather for, quote, a pattern of misconduct proved by clear and convincing evidence and showing a, quote, flagrant disregard for the law. That's what the high court said. And essentially our understanding is that she wouldn't be able to be appointed as a judge or run for at least 7 years because of this. And apparently she was accused of numerous violations of the Georgia Code of Judicial Conduct going back to 2021 and 2022. There was one where it was found that Peterson wrongly held a woman in contempt of court without providing her adequate due process. And when she was questioned by a disciplinary body about this, Peterson, according to the court, that she offered up, quote, untruthful testimony about her reasoning that, quote, underscores her conscious wrongdoing. This is from the high court. There were also apparently issues of decorum and courthouse behavior, but the bottom line is she was removed. Now, I have to tell you, for purposes of this civil lawsuit, she is still a licensed attorney in good standing without a history of discipline in that capacity. This is according to Georgia State Bar records. And so now she's filed this lawsuit. She's filed this lawsuit against the city of Atlanta and Officer Wadsworth. So She basically claims that Wadsworth not only physically violated her, but after telling her she was being arrested for disorderly conduct, quote, plaintiff was placed in the back of defendant Wadsworth's patrol vehicle and detained for 4 to 5 hours, during which Wadsworth drove erratically, stopped at undisclosed locations, exited the vehicle multiple times, and made private phone calls. Plaintiff's detention was punitive and pretextual, not investigatory, and occurred without probable cause or prompt judicial determination. And she argued that her case was elevated to felony obstruction, quote, based solely on the false allegation that plaintiff battered defendant Wadsworth while he was purportedly investigating a crime. Quote, defendant Wadsworth falsely alleged that plaintiff struck him with a closed fist and or shoved him and struck him in the head and or chest. These allegations were knowingly false and were made to justify defendant Wadsworth's unlawful use of force and prolonged detention. And in terms of the city, a lot of this is about the body-worn camera. Quote, on June 21st, 2024, the city approved, released, and affirmatively promoted edited and curated body-worn and dash cam footage that implied plaintiff committed felony obstruction and battery on a police officer. Such approval and release decisions were made by city officials. The city released and promoted these materials before any judicial determination while felony charges were pending. After the felony charges were dismissed, the city continued publication of the misleading footage and narratives without correction, disclaimer, or contextual clarification. The city further permitted or failed to prevent the premature dissemination of non-public arrest allegations, including the specific claim that plaintiff struck defendant Wadsworth on the head and or chest before booking or lawful public release. Prior to plaintiff's arrest, defendant City of Atlanta was on notice of allegations that defendant Wadsworth had engaged in unconstitutional arrests and uses of force in prior incidents and litigation. Despite such notice, the city failed to take reasonable corrective or preventive action and continued to deploy defendant Wadsworth without adequate supervision, discipline, or restraining. So that's important to try to get the city on the hook. So what is she claiming? What are all the causes of action? Well, the first one, count one, this is 42 U.S.C. 1983 claim, very important. It's for false arrest. So this is a specific federal law that says any state actor, like an officer, who deprives somebody of their rights can potentially be held legally liable. So here, the argument is that Wadsworth, right, a police officer for the state, arrested her without probable cause that she committed a crime, that this was a violation of the Fourth Amendment. You know how somebody has a right against unreasonable searches and seizures, that a warrant needs probable cause? So this is because she claims Wadsworth didn't see her commit a crime, didn't conduct a proper investigation, that she didn't obstruct or interfere with Wadsworth in any way. And what he did was allegedly unreasonable. That's the key term, unreasonable. And she claims, and this is important, I'll talk about it in a minute, that he is not entitled to any sort of immunity here, that he can be sued. Talk about that. Count two, again, another Section 1983 claim. This is for excessive force. Same federal law. Again, she says this is a violation of the Fourth Amendment because the Fourth Amendment protects the right to be free from excessive force during an arrest. And so the claim here is what he allegedly did was objectively unreasonable under the circumstances because she claims she wasn't an immediate threat, she wasn't resisting, she wasn't fleeing, and yet she was allegedly slammed to the ground and had force applied to her neck and back. And so she claims that defendant Wadsworth used force against her that was objectively unreasonable and excessive under the circumstances. Count three, again, another Section 1983 claim. This is for unlawful detention and false imprisonment. By the way, these are all against defendant Wadsworth. But so you're talking Fourth Amendment again, unreasonable seizure. Here, she was allegedly kept for several hours without probable cause or a warrant or a court order. So it served no legitimate police investigatory purpose. You can't be subjected to prolonged detention like this without more. Count four, another Section 1983 claim. This is for malicious prosecution. Essentially that you can't be criminally charged or move forward through the criminal legal process without probable cause. So here, you can't be criminally charged, you can't move through the criminal legal process without sufficient probable cause. And here, she claims that the probable cause asserted by the officer, Wadsworth, was supported by false statements and misleading information. Count five, state law, false arrest and false imprisonment. This is a state law Georgia claim Basically, the allegation is, quote, defendant Wadsworth knowingly and intentionally arrested and detained plaintiff without lawful authority. You have count 6, again, state law. This is battery. Here it's under Georgia law. Defendant Wadsworth intentionally and without justification made harmful and offensive physical contact with plaintiff. Count 7, again, state law, Georgia law. Assault. Defendant Wadsworth intentionally placed plaintiff in reasonable apprehension of immediate bodily harm. Count 8, this is back to the federal Section 1983 claim. Stigma plus due process. Okay, so this is against the city of Atlanta. Basically, you're saying the government violated your rights. And here, the allegation being that the city of Atlanta, quote, publicly disseminated false and misleading arrest narratives and police video footage portraying plaintiff as having committed violent felony offenses, including felony obstruction and battery on a law enforcement officer. The stigmatizing statements and visual depictions disseminated by the city were false and were published with knowledge of their falsity or with reckless disregard for the truth, kind of like defamation language putting in there. The city's dissemination occurred through official channels and with command-level approval. The city's official dissemination and continued publication of false felony arrest narratives and curated police video footage independently imposed an ongoing legal and practical burden by publicly branding plaintiff as a violent felon without adjudication, without affording her any name-clearing hearing or meaningful opportunity to contest the city's official account, thereby altering her legal status, professional standing, and liberty interest in a manner distinct from and in addition to the underlying criminal process. Kind of like a little bit of a due process claim there. Count 9, this is municipal liability under Monell. So this is again against the city. And Monell, whenever you hear that, it establishes that local governments, cities, counties, departments, they can be potentially held liable under a Section 1983 claim, but not on a theory of respondeat superior. What do I mean by that? So you're not saying that simply the actions of an officer can hold the city liable. Instead, what you are saying is that liability for a government, for a city, arises when there is a constitutional violation coming from an official policy or custom, something the government set out, something the city set out that caused that person's rights to be violated. What's the argument here? That the city of Atlanta, quote, defendant city of Atlanta through the Atlanta Police Department was responsible for the supervision, discipline, training, monitoring, and deployment of sworn officers, including defendant Keith Wadsworth. Prior to the incident giving rise to this action, the city had actual notice that defendant Wadsworth repeatedly violated APD rules. The sustained violations were not isolated or aberrational. Rather, they reflected a recurring pattern in which defendant Wadsworth failed to comply with directives designed to regulate officer conduct, ensure accountability during citizen encounters, and safeguard constitutional rights. Despite this documented pattern, the city failed to implement effective corrective measures, including meaningful supervision, targeted restraining, monitoring, reassignment, or restrictions on defendant Wadsworth's enforcement authority. Now, I'm not privy to his past, perhaps disciplinary actions or his past law enforcement work, but potentially this could be problematic for both Wadsworth and the city if true, if they were put on notice of something. And what is she looking for? She's looking for damages. Looking for damages in an amount to be determined by a jury believed to exceed $50 million for physical injury, emotional distress, loss of liberty, widespread reputational and professional harm, and also punitive damages like punishment damages against defendant Wadsworth. Okay, few things. I laid out her claims, kind of laid out what her evidence would be, right? And also I said if the charges were dismissed, could potentially be helpful for her. You know, if she can show that Wadsworth has this history, again, could be very positive for her. But a few things. So I am just going to be giving potential counter arguments here as someone who's not connected to the case, don't know all the facts, but Officer Wadsworth, in my opinion, will most likely argue a few things. First, probably will argue that he followed the proper protocols of the arrest. He was following his training, that he had probable cause to arrest her based on the circumstances at that time, that he followed the guidelines, that he followed the training, the protocols of how to arrest somebody in an open environment like that he didn't do anything counter to that he didn't do anything excessive, maybe use the body cam to support that claim. Usually in these cases, there's a lot of back and forth on use of force and training and manuals. But you put all that to the side, I also think he's going to be arguing qualified immunity, okay? Now, qualified immunity essentially protects officers from being sued in the performance of their duties. Makes sense because officers should be able to feel that sense of protection in order to properly carry out their duties, not have fear of being sued every 5 seconds. However, that can be pierced. It's not absolute, okay? So that immunity can be pierced if it can be demonstrated that the officer's actions violated a clearly established right under the Constitution or law. So that can be difficult to show, a clear departure from what an officer was supposed to do under the circumstances. You have to show that what they did was objectively unreasonable. Oh, and by the way, Wadsworth may, deny the allegations of any kind of past performance issues or disciplinary actions, not sure. The city is probably going to do the same thing. They may contest that he had prior disciplinary actions or there were prior issues. They'll say they didn't have any notice of that, no knowledge of him doing anything. Or they may say, hey, listen, what he did is what he did. You're trying to hold us liable for what he allegedly did. He went rogue. He did his own thing. It wasn't our fault. And it doesn't work under that specific law that you're suing under, right? I mentioned before that you can only sue us under Monell. You can only sue us if we had some sort of custom or policy in place. We did everything right. He went rogue. Maybe try to distance themselves from Wadsworth. That's one thing. Or they'll defend what he did, right? They'll look at the training, they'll look at the manuals, they'll look at use of force and say what he did was reasonable under the circumstances. We did everything we were supposed to do. You weren't violated because of our policies or our customs. Now, I do have a little bit of trouble with the releasing the body cam issue because especially body cam and in a public setting, right? In a police cruiser, booking, it's different than in someone's home. You could say there's a limited expectation of privacy there. It's part of the investigation. But, she makes this allegation essentially that maybe the footage was manipulated or tampered or curated in a way. I don't have any evidence to suggest that. But if she can show that, right, that's different. If you can show there's evidence that someone tampered with evidence or the video was manipulated to serve a false narrative, that's interesting. But look, generally, the production of body cam or arrest materials or court footage, you deal with FOIA, you deal with First Amendment considerations, the public having a right to access to these materials. And any defendant, I also have to think about this, if any defendant where charges are dropped or they're acquitted could claim that nothing should have been released. There's a side question about whether or not it influences a jury or that, but whether or not those materials should even be made public if the charges are ultimately dropped or someone's acquitted, I haven't seen a lot of that. I don't know if that's necessarily going to work because wouldn't any defendant who's acquitted or the charges are dropped say none of that should have been released? I'm not entirely sure. I'd have to look at that a little more specifically, especially under Georgia law. But again, it's an interesting argument. And she also kind of throws in that defamation language that I mentioned before. I also have to mention, it is interesting she's representing herself. She can do it. It's her right. She can do it. And she is an attorney. But always complicated. There's a conflict of interest in a way. You kind of want an objective, neutral analysis. That's why you want somebody to represent you. It's always usually best policies to let somebody do that, to fight for you in these circumstances. And I will tell you, in terms of being your own advocate, in the last few days, Peterson posted kind of these glamour shots of herself on her personal Instagram page. There was the caption, "Taking everything back that was stolen from me." That's the comment. Then you have the hashtags, "It's my time," "The year of redemption," "Reclaiming my time," "Clearing my name," and "Justice for all." That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can also check us out on NBC's Peacock. We're putting episodes up there as well. If you want to follow me, you can check me out on X, Instagram, my News Nation show, Jesse Weber Live. I'll see you next time, everybody.